Hello and welcome to episode number 6 of Jam in the Print Room. I'm Andy McGuinness from SEDO Large Format Solutions, and I'm joined as ever by Jack Gocher from Ion Display and Matt Hanley from M2 Search.
Morning.
Hello.
Morning. Hello. We wanted to provide an opportunity for learning on this podcast, which might surprise some of our regular listeners. This episode we'll be discussing mergers and acquisitions and the process of how you can buy and sell businesses. As you can see, we're joined by another special guest who's going to support us on this topic, ckelly from Aquabridge Law. Thanks for joining us, Craig.
Thanks for inviting me, guys. It's great to be here. Cheers. Thank you.
And how's everyone been since the last podcast?
November's been good. I think it's the last cut-off for recruiters to really be busy and try and get some people in for either December starters or January starters. But it's been good.
I think November is psychologically kind of a busy month for planning stuff for next year. Certainly on the magazine side, advertising budgets are being agreed as we speak, so it's not too late, guys. But yeah, no, it's been a busy month. Looking forward to a slightly calmer December. Yeah,
this month's been really good, actually. We've seen some really good inquiries for the big stuff. So the flatbeds, the roll-to-roll, 3.2 metre UV. So yeah, we've got a lot on the go for January, actually. So my January is going to be mega in terms of going over to Italy for Vanguard demonstrations and those kind of things. So it's looking really positive, which is good. How about you, Craig?
Yeah, well, with the budget, the 30th of October was the big deadline for most of our clients to sort of the M&A, because we wasn't sure where the capital gains tax was going to end up. So we had the big rush there, and we thought there was going to be maybe a lull then until Christmas, but no, it's been as busy as ever. So yeah, now we're in the build up to Christmas. Everybody wants to complete beforehand. So yeah, we're in for a busy December, yeah, and right up until it actually rises, all the capital gains taxes and that sort of stuff.
That's good to hear. Would you mind just explaining a bit about who you are, what you do, and your career so far?
Yeah, sure. So my name's Ckelly. I'm a solicitor at Aquabridge Law in Chelmsford. So I'm a corporate commercial solicitor, so I deal with all aspects for business law. So from the beginning, in the middle to the end. So I can help you set up your limited companies and do the setting up your businesses, help with all of the paperwork. So example like shareholders agreements, terms and conditions. And then our main focus is what I really deal on is the mergers and acquisitions side. So the buying and selling of businesses. So whether that's limited companies or sole traders or partnerships, I deal with that aspect as well, and also have a background in intellectual property law, so protecting brands and dealing with copyright and trademark law. So yeah, I did that many years ago now, but now just sort of focusing on the mergers, acquisition and corporate commercial side of it.
How long have you been doing that for?
So, well, I've been qualified now, coming up to 5 years next week, but I was working in the legal profession before that in trademark law for about five years before that. So yeah, so just turned 40, so sort of, so been doing it for a long time, jobs in it, but actually fully qualified solicitor just for 5 years, yeah.
So what's the kind of, we want to be discussing about how print companies can acquire other print companies or someone who's exiting their business. What's the kind of the role of a solicitor within an M&A structure?
So it's depending when the client gets us on board. So usually it'll either come from an existing client or a client which is, found us online or through a referral or from an accountant. So we can be there right from the beginning, from the heads of term stages, or sometimes they're already agreed and then the solicitors then get involved from that. So the heads of terms will lay out exactly how the process will be working. So, for example, the purchase price, if there's going to be any special considerations in it, for example, like a deferred consideration where not all the money's paid up front and then it's paid over time. So that will all be included in the heads of terms. So the heads of terms are not legally binding unless they say that certain clauses are legally binding. So they're there really just for a guide. Usually what you will see for the heads of terms, legally binding clauses will be confidentiality clauses. So, for example, not allowed to speak to anybody else about the deal, etc. And also about fees, for example. So if there could be a clause in the heads of terms stating that if the matter becomes abortive, so if the sale doesn't go through, then the fees of perhaps the seller or the buyer will be paid by the other party. So, for example, if one of them pulls out of the deal, then they will have to pay the reasonable legal fees or accountant's fees for the person who's not going to be participating anymore. So yeah, from the start of it.
And how would you normally go about kind of arranging a fee with the customer? Is it done on an hourly basis, or is it a fixed fee up front, or is it depending on the turnover of the company, those kind of things?
Yeah, so the fee would depend on a lot of things. So we do we have an hourly rate which we can work towards, and then we have to then charge for, for example, per email, per telephone call, and then for the time that we spend on the documents and this sort of thing. Or we can have fixed fees that you can work with clients where we say it's going to be X amount, and then but if it does go above that, then we have to speak to the client and say, look, we know we said it was going to be X amount, but matter has gone way over, and then we need to sort of evaluate the fees that they're going to be paying.
So, I mean, it's like, the rest of us would probably come across this issue. Like, you must get a lot of people ringing you for guidance and advice before you get to that billing stage. How do you deal with that?
Yeah, so from the initial call with the client is always for free, because we need to know, sort of understand where the position is for the client. And, well, it'd be unfair if they were to ring for a service and then we start to charge them straight away, because, it wouldn't be right. So what we do, we have the initial first meeting, which is either Teams or a phone call, and we just discuss exactly what's going on in the matter, at what stage they're at, because the fees will depend on where they are. So, for example, if they need us involved with the heads of terms and negotiating them, that can be a long process. So we will sort of then base our fee on the amount of work that we're doing. That's sort of where that stage is. So we just sort of work out from there.
Typically, when do you become instructed by most customers?
Well, hopefully, from a fee saving perspective, for a client, it would be best if we were instructed after the heads of terms have been agreed. Therefore, then we can just get straight into the paperwork, and there's no back and forwards between the solicitors saying, well, we think it's going to be X price. Well, we think it's going to be this. Then it goes back and forth, back and forth. And if that's just led between the clients, between the buyer and the seller, then there's no fees being in cost. It's just their time, but you're not paying for a professional's time for them to negotiate something which you guys can do on your own. And then it just makes it a lot easier for the solicitors and the accountants involved then to be able to produce the paperwork based on what was agreed and signed before we even got involved. So, but some clients may need our help with the heads of terms, and that's why we are there at the beginning and we produce them for them, or produced by an accountant, and then we help them through the process. So it's depending how confident the clients are in dealing with that side of the process.
And I think it's knowledge, is it not? Because I've never had any experience of this at all. Like, how would you, if I was to go looking for a business to buy or sell mine, I wouldn't have a clue how to do heads of business or anything like that. So is there someone that tells you how to do it, or is it just common sense if you know it?
Well, I suppose having that guidance. So when you're talking about where you look to buy and sell businesses, you have merger and acquisition brokers that have access to both the buyers and the sellers, and will put the deal together. A lot of those guys that we work with, if the buyer or the seller hasn't got a solicitor, then they will contact us and say, look, we've got a client working at the moment looking to buy, sell a business. Will you be able to provide the legal support for them? So you can sort of get a grasp of where people are. So say, for example, it's someone that's been in business and they sold and bought businesses before, may not need the assistance with the heads of terms, and they may just sort of do that bit on their own. But like you said, if you're a novice and you deal in your profession, which you're great at, but not on that side of it, that's where...
Stop it.
And that's where the brokers then come in and can assist, and that's where the solicitors can come in and assist as well. So it sort of works both ways, and you sort of, and I think that, and also even if they have been agreed, sometimes we still have to negotiate and amend the heads of terms, because like you said, they may have not been done correctly, so we still have to do a little bit of work on them anyway. But from the perception of a solicitor, we are nice people, most of us, and you just ask us questions. That's what we're here for. We understand that people need that, and there's never a stupid question to ask. I would rather someone come to me and say, actually, Craig, we don't understand this, or we need a little bit of help with this, than doing it yourself and then having to do it again. And then we can just sort of work on it together and make sure the deal's done correctly. That's how I prefer it anyway.
For a stupid question, you're going to regret saying that with me, but anyway.
No, never.
I was just going to ask, I know you touched on it a second ago. Has someone ever made such a mess of their own heads of terms that you've had to say, this is a terrible deal?
I was trying to think. I suppose when it comes to the heads of terms, because they're not legally binding, we can always influence anyway. So say, for example, if it's the purchase price or how the consideration is going to be paid, and they said, oh, it's going to be X amount, but then the accountant steps in and said, well, actually, we think your business is worth more, and you're sort of, they can be amended. That's not a problem. It's just whether the clauses which are made legally binding, for example, like the confidentiality clauses or the fee payment clause, if they're made legally binding, you can't get out of those. But the heads of terms are really just a guide for you to use, and also really just for a template for the solicitors to use for the document, so we know exactly what has been, our purchase price, how it's going to be paid, etc., etc. But it can be amended, and sometimes the heads of terms are completely wiped and not used because the deal gets constructed completely differently halfway through, for example. So it does happen.
Who decides on what section of those heads of terms and heads of business are legally binding? Is it my non-negotiables that I can say, right, that is legally binding, I don't want to waver on that?
Yeah, usually it's the confidentiality clauses, because you don't want to be, and you don't want the other parties telling people that you're in negotiations looking to sell your business. Because if people are starting to sell their business, people hear about this. Oh, what's wrong with the business? Why are they looking to sell? What's going on? And it can create sort of instances like that. So that's why we have that one as legally binding, just to keep it all confidential and that nobody's going to be talking about the deal. And also with the fees, that's usually one that people will want as that, because they're not always in the deal, because sometimes it will say at costs, for example, each party will pay their own costs to the transaction, their legal costs and all the professional costs. But if you're looking, to have some stability and some comfort that if one of the parties pull out, then you can have a clause in there to state that if they unreasonably pull out for not a valid reason, then those fees will be paid. And that's why you'd want that to be legally binding. So then you can enforce that when the fees are due.
But it's either the seller that can dictate that just off their own back.
Yeah, and then the buyer could then also come back and suggest, we want this as well, then if you pull out. So that's when the negotiation comes in. So we've already we've gone through it there. Well, the seller just wants it, but as the buyer, you may want it as well. So it's just about having that negotiation through the time, and that's where the time can build up in negotiation. So if the heads of terms are usually settled before they come to the solicitors, then you just save on a little bit of time there.
Totally get it on the confidentiality thing, because it's quite an emotional thing, isn't it? Blood, sweat, tears, maybe passed down from generations and things like that. And you've got a workforce there that don't want to know at the very kind of drop of a hat as well. So I guess there's lots of things to take into account.
Yeah, it can be unsettling for staff members, especially if they're seeing that emails going across. So, for example, if the MD has a PA, for example, or an assistant, that he or she sees the emails, if they're seeing things from solicitors coming in about, the sale of the business, the first thing that would come into my head is my job in trouble? What am I going to do? Then it starts to create panic in the workplace, doesn't it? So keeping all that confidential and trying to keep it separate from the business I think it's the best way forward.
Absolutely.
Okay, and from the buyer's perspective, what's the kind of timeline and route to completion, really, from speaking to the seller to completion, taking keys?
So you're saying, the time frame from start to finish? Well, it could be varied, really. It all depends on what I always say to clients is, we're only as quick as the other side solicitors and their professionals. So when you act for the buyer, so say for example we're acting for the buyer, the buyers will produce the paperwork, so the share purchase agreement or asset purchase agreement, whichever one you're using, and then we send it across to the seller's solicitor, and then it's for them to review and then to give us comments back. So it's all depending on that sort of thing, and also on the sellers. If you're acting for a buyer, you're going to be raising what's known as your due diligence about the company. So the sellers will set up what's called a data room, which all parties will have access to, and then the sellers will upload documentation and information about the company based on the due diligence questionnaire, which will be prepared by the buyer. We will have access to it. We then review that as part of the buyers, and then on the other side, the sellers are then reviewing the paperwork that's being produced. So it's just how quick both parties can do that. And if from the DD there may be something which the buyer says, actually I didn't know about this, or we wasn't aware about this from the company, or the business. So they may have to do some further DD. They may have to put other things into place, and it happens. And also there could be such a big thing in there that the buyer says, well, actually, we don't think the business is now worth this. And there may be negotiations with the seller saying, well, if we have to cover X amount because of an incident which is happening, we'll take it off of the purchase price, and then we would cover that when we take on the company. So that's where it can lead to. But we could have a great business where there's, the DD's done properly, the other side have done all the paperwork, comes back, and we can complete really quickly. But I'd say on average of a process, I would give it a good 2 months, good 2 to 3 months would be a reasonable time to think actually it is going to take that long.
Which isn't a long time, is it?
No, I didn't think that either.
No, yeah. So that's on a good one. That's on a good matter. But then I've been working on matters that could last 6, 7, 8 months because of the complexity and how deals change and people doing other things at the time. Oh, we haven't got time to deal with this purchase at the moment. So it happens. But yeah, a couple of months and you could see yourself through. Yeah.
So does that depend on the kind of size of the business as well? So a 2 to 3 month time frame could be a company that's under 1 million, and 8 months could be something that's over 10 million, for example.
Yeah.
Or does it not really happen like that?
The more complex, the bigger the fee, the bigger the business, it would tend to be longer because there is more to look into the company, and the buyers are going to look for more assurances that what they're buying for such a huge amount of money is what they're buying. So the DD process may be a bit more intense, and the warranties which are going to be given in the share purchase agreement or asset purchase agreement, they're going to look to really want them in place so that they've got something to cover them if anything does go wrong. But you could have like a smaller deal, like you said, for under, for £50,000, for example, which is an asset purchase where you're just buying a book of a company, which could take next to no time because there's no staff members. All you're doing is transferring across the book and the goodwill, and you just want to make sure that everything's in place and that's it. So those sorts of deals could take the shorter time. Yeah. So it all depends. It all depends.
You will have more of your sort of ducks in order prior to going into these deals, which presumably helps. Is there some advice that you can sort of give to people to how they can prepare themselves before sort of embarking on this?
Most definitely. So if you are thinking about selling the business and you've got an idea that you are going to be selling, having those, like you said, your ducks in a row is key. So example, having everything about your employees all up to date, all in order, all of your contracts up to place, all in order, knowing where they are, what you could do, because they're all going to need to be provided in the in the due diligence process. So having that paperwork to hand, and when they ask for it with your solicitors, you can then, right, I've got it. It can all be uploaded to the data room, and it's not taking all that time. So being prepared and having that sort of things in place is great. So speaking to a professional, if you are thinking about, maybe in a year's time, I'm thinking about selling my business, have a chat with, with an agent, an M&A agent, your accountant or a solicitor if you know them, and just really have to say, look, what do I need to be looking for now to get myself ready for that in 6 months to a year? But it's paperwork, really, because that's what all the buyers really want to be seeing is how much money you're making, how your business is run, is it running well, and can we see that now before we buy? So it's just about getting that paperwork prepared.
And which type of paperwork would they be asking for? Obviously, sets of accounts, books, those kind of things. Anything else they would be asking for?
Yeah, so any big contracts that you have with the business. So, for example, one business could be based on, you could have a huge customer, which is like a 90% of your whole business, and just ensuring that there isn't sort of any like change of control clauses in those contracts. Because if the owner of the company changes with a change of control clause, the other party can end that contract without any ramifications for it. Just looking at those contracts and making sure that you can do that, because 6 months down the line, you could be thinking, oh, actually, they could jump out of this contract and my business could be worth nothing because that contract has disappeared. So just ensuring and knowing what's in your documentation and in your contracts for, if you're providing services or goods and services, knowing what's in them and knowing what will happen if you do sell your company and there are new owners, will that have any impact on the company? Just really just reviewing your paperwork and knowing what's in there.
So, for argument's sake, let's say Andy's selling his business. Jack's one of Andy's customers.
Yeah.
Andy leaves. I take over, and Jack goes, "No, I don't want to deal with that. I'm out." Then I'm left with £1 million down. My old guy's not there, and I've lost my new customer that I valued the business on.
Yeah, so that's exactly it. So
Wow.
a change of control clause, it has to be in the contract. So, for example, it might not be in all of them.
Mm-hmm.
I think one of these aspects is if you build up that great relationship, like you said, if Jack and Andy had a really good relationship, worked together for a long time, and the reason why Jack chose Andy was because they got on so well, Jack may then not want to deal with you, Matthew. Sorry for that. You're just in the example, may not want to deal with you going forward because he doesn't know you. There's not that trust.
It's true.
And that's where that covers the other parties entering into the contract, so they can change it. But the contract will be with the company and not Andy personally anyway. So it will just depend. So if you were to buy the company and there is no change of control clause, then you'd be fine because it's still with the company. So it's just about knowing about these little twerks in contract, knowing that if it does change control, just knowing how to deal with that and going forward.
But if Jack does then back out 6 months down the line, there's no what's the comeback on the kind of agreement and the deal? Is there anything that can be done, or is it just tough luck?
It's whatever is in the contract. So for example, termination clauses will usually have, it will give you, we have to give 6 months or a year's notice in writing. So it's all just depending with Jack what's in that contract, whether he can give his notice, and vice versa. So it's just all about understanding what's in your contracts going forward. So there's probably a lot of these contracts which people are working on at the moment that wouldn't even know how to get out of it. And if they do want to get out of it, they don't know. There could be financial punishments for it. So it's just about knowing what's in there to ensure that you can move forward with your business the best way, because it's difficult otherwise.
But let's say it's in there, and I as the buyer know that it's in there. But then 6 months down the line, Jack has given his notice and leaves. That's just tough luck from my side of things, is it?
So what we would do from your perspective is, as a solicitor, if I was acting for you as the buyer, while we were reviewing this, we would say, Matthew, just to let you know, the biggest contract, the 90% that's bringing in the £1 million a year, has a 6 month termination clause. We would also speak to the sellers and ask them, in the DD process, what is the likelihood of them ending this contract? And as a seller, they're quite right, they're going to say, well, we don't know. How long's a piece of string? We don't know what's in Jack's mind. We don't know what he's going to do. It's just the assurances that we're going to have to look for in that contract to say, well, it's the risk. And as a solicitor, we have to raise that with you to say, look, this is the biggest contract. This is what you're buying. We just have to make sure that you're aware that there is a 6 month termination clause in there in the contract. And that's it. But also there probably could be negotiations beforehand that Andy might chat to Jack and let him know that you are selling the business. And if it is that big of a contract, then he may get an understanding, and Jack may go, actually, well, no, we're probably not going to. And then that may influence you, Matt, in buying the business. So it's just about being inquisitive. And that's what your solicitor's on board for, to ask those awkward questions so you guys don't have to do it between yourselves.
So could we so Matt and I go to Jack and say, this is what we are planning to do, and put a pre-contract, or, should this happen and Matt takes over the business, then Jack's happy he's signed ahead of the merger and acquisition?
Well, because it could be difficult, and Jack then could still just turn around and say, I don't want to do it in the future. It would be hard, and I think it would be very hard to maybe try and push that across to somebody else, because it's effectively trying to promise something in the future which might not happen anyway, and like saying they might change their mind, I don't want to do that. But it's just about being aware of these contracts, that if they are that big in an industry like yourselves, one supplier could be that big, could make the whole company. So it's just about making sure that those contracts are watertight and knowing what could end one of them.
Is this why we see that when an acquisition does happen and I say to Andy, right, okay, stay on for another 12 months, kind of smooth that process through the kind of amalgamation of the two companies, reassure the customers, here's a 6-figure salary, You've got a 12-month kind of clause.
Well, Andy's accepted. That's it. But that's effectively
Brilliant. We're in. My heads of business are not legally binding.
So Andy would then stay on under what's probably a consultancy agreement, and then that would then just state that he's going to do X amount of hours for the $100,000 a year salary. That then gives stability to the clients moving forward, that there's going to be they're still there for the whole year, putting over the processes, teaching him how the ways of that, and then again that would give the seller, the buyer, a bit more stability, and also the clients a bit more stability, knowing that Andy's still going to be there looking after the business. But most of the time when you buy a limited company, the staff will stay anyway. So it's only going to be the actual change of the ownership, the running of everything that's doing it. So, for example, the printing work will still be done by exactly the same people, 9 times out of 10, unless they go. But it's just from the client's perspective, they just need to make sure, thinking, is this still going to be the same business, even though it's run by somebody else?
The question we had through LinkedIn, actually, from Marcus.
Okay.
He's talking about how deals are structured and deferred payments. I mean, if you've got a situation like that where one contract is the majority of a business, would that be sort of a part of the deal? So you say, well, we'll pay the second amount of the deal next year, assuming all the revenue carries on as it is.
Yeah, exactly. So deferred consideration is quite a popular way to do it. So what we do is, it's known as the completion money. Completion funds will be paid on completion, so X amount, and then over a certain period of time, at certain dates, the money will then be paid as deferred consideration, then for the purchase price. And the sellers, for example, will look for some security for that. So maybe have like what's called a charge over the shares. So if the deferred consideration isn't paid, then the shares are returned back to the seller. So it's just sort of giving the seller some protection, because effectively it's a loan, but want of a better word, it's because that money's still outstanding. They still need to be able to get that money returned to them for the shares that they've bought. Yeah. So deferred consideration is a popular route to use.
Are there any other methods of finance that you could do to purchase a company?
Yeah, well, you can do what's called earn-out provisions as well. So an earn-out provision is where if certain targets are reached for the business, say for example turnover or profit, then the seller will then receive further additional money as part of the price. So it just sort of then backs it up, doesn't it? Saying, well, if the seller says, well, we reckon we're going to make X amount of money, the business will make X amount. So okay, that's fine. If you do reach those targets, then we'll be entitled to more money. So that's another way to do it.
It's all about mitigating risk, isn't it? If you pay a lump sum for business, you might lose contracts, it might make double, but you've agreed that amount.
And it's effectively like you're buying a house. It's like you're buying a business. You do your due diligence, like you do your searches on buying a property. You go and visit it. You go and have a look around. You look at all the structure of how the business is made. What are the contracts like? What are the employments like? What's the accounts like? And the due diligence process is probably one of the most important aspects of it, because you need to understand what is in that company before you're buying it. And as long as the sellers, well, they usually will be as outgoing as possible and give you everything you require. And then it's for you guys with your legal team and your accountants and whoever other professionals you have on board, just making sure that it's the right deal for you. And if you need to make some amendments and changes to, for example, the purchase price or something like that, or the way the money's paid, having that in the agreement to show that that's how the deal is going to be structured. It's just about making both sides as comfortable as possible. That's the most important thing, because it's a hard process. I think we discussed this in our pre-meeting that selling a family business, for example, especially, it's hard, because you could have had it could have been your grandfather's or your grandmother's business, and they built it all the way through, its family run, and then having to show all of that to the world and then selling it. It's quite personal. It's a very personal thing. So I think parties take that into consideration. We certainly do. When we see a lot of local family businesses selling to bigger corporate businesses, so yeah, you have to try and be sympathetic with it, because it is like a family member you're sort of selling. And it's been their whole life. So
it's exactly that. It's people's lives, isn't it? And it's not it's not a well, it is a transaction, but you've got to have empathy there. There's the whole kind of world of other people that you've got to take into account, all your staff, all the staff of the kind of buyers, all the sellers, depending on what side you're on, the longevity and everything. It's not too dissimilar to hiring somebody. It's such a massive decision to other people as well.
It is, and it has an implication. Like you said, if you hire, 10, 15 members of staff that are in the local area, you're a local business, that, they're all in the community. It's all there, isn't it? And their families, and you provide for them. And, you could be one of the big aspects in that whole sort of place, and selling that business could have a big implication on everybody. So it's just like you said, it takes into those factors. And sometimes it is an aspect that, sort of when you're involved in the paperwork and the money talking figures, it's something that's sort of not pushed to one side, but it's not really considered. And it's good to hear when you're talking to people like yourselves who've been through the process that you are humans on the other side of both of it, and it's not just the paperwork and the money that should be involved.
I'm sure the 6-figure salary or £4 million payout it softens that, but it still has to be taken into account, doesn't it?
It does, definitely. Yeah, it does.
Do you have a preference to, which side you're on, buyer or seller?
Well, because the buyers prepare the paperwork, then working for the sellers sometimes, because you're providing the DD, you're providing that sort of stuff, you're just doing a lot of giving of the information and just amending the documents, where if you work for the buyers, you're preparing everything and reviewing everything. So it has its ups and downs. But if I was had to choose, I'd probably say sellers I prefer working for, because then it's a sort of a fact building operation, and you're getting everything into order. And I like all that, putting everything to the data and making sure it's all numbered properly, sort of a OCD kind of thing, making sure the numbers are all correct. And and then then you get to evaluate the paperwork and not have to prepare it. And then you sort of know what your client needs and what the deal needs to be structured. So then you can you amend the documentation as opposed to putting the first drafts out there. So just preference for me, probably sellers, I would say.
As a recruiter, I represent both clients and candidates in the same transaction. So a seller and a buyer, right? So can you represent both of them, or is that conflicts of interest when it comes to law and things like that?
There are certain ways that you can waiver the rights and this sort of thing, but I personally think it would get too messy, because obviously if you're working in the same office with someone that's working on the other side, it does get a bit. So preferably it would be two separate. I think that there are ways that you can do it, but usually in the years I've been doing it, it doesn't tend to happen, because people know it has to be separate, and it doesn't tend to happen.
There's so many similarities there to recruitment, and we act as an intermediary between both the employer and the employees. So I didn't know if it was the same on your side.
Yeah, I think if you're acting for buyers and sellers of the company, it's difficult, because we're putting things forward. For example, if you're working for the buyer, you want to have as many warranties given by the seller as possible, because you want to make sure that everything they say about the company is true. Now, if I'm on the other side as the seller, we want to try and limit our liability as much as possible. Whereas when you're working for the buyer, you want to put as much liability onto the seller as possible. So if you were working for the same, the conflict would be huge, because one side of me saying, right, we're going to go all out, and then the other one, oh no, we want to push back a little bit. So it'd probably be a bit difficult.
It's no different to recruitment.
Yeah.
A salesperson, the client wants you to deliver £1 million. The candidate's like, oh, I want to do $500,000. Yeah. So it's just about setting your stall out, isn't it? I guess
it is, and I think
me.
Yeah, that's your two conflicting interests there. You're kind of mediating between the two, but it's in your interest to make sure it all works.
That's why I've got grey hair and I look as old as I do, Jack.
You look a veteran. Look a veteran of the industry.
Yeah, it's not easy, but
I suppose it's similar to estate agents as well, isn't it? They've got both sides of that, and they're trying to broker a deal.
Yeah, you kind
of exactly.
Just working for the seller. Or in all cases, so you've got that in the back of your mind. With yourself, Craig, you're working for whoever you're working for. And Matt, you're working for both. So great.
It's weird how there isn't a distinct kind of a candidate kind of recruitment company and then a client recruitment company. Actually, now you said it, but I'm glad there isn't.
It is. Yeah, having been through the process myself a few times, it is. It's sort of. But I suppose when it sort of comes to recruitment, just from my own experience, it's sort of me going to interview and then them sitting there knowing what they to expect from me. And it's also from the reputation of the recruiter, because they can't waste that person's time. So if they put a bad person forward, it's not good for them. But also from the other side, if they've accepted you for interview based on that, then you've sort of met some sort of standard. So it's not all on the recruiter. It's sort of on both sides of the pipe, because as somebody going into the interview, I would have had a look at the company first. I would have seen what they're all about. Do they do what I want to be doing? So sort of a mix. So just trying to take it off you there, Matt. It's not all on you, is it?
No, it's people at the end of the day, isn't it? You make your own choice, and it's your career. You decide what you want to do. But again, it's having that empathy, isn't it? And it's not a transaction. It's people's lives.
I guess it's the same thing. It's fine if it's all working smoothly and the negotiations are going well and everyone's happy. It's when you hit a wall or something that it looks like it's all going to fall apart. That's when you need to get in and mediate and do whatever you need to do to keep the deal on track, if that's what people really want.
Yeah, and also it's also about, one of the biggest aspects we find is when clients then talk to each other without telling the solicitors. So we have an idea of one thing which is going on. We know what's going on, so we think that's the position. And then Jim will say, I've spoken to Jill and we've now agreed this. Now, has this been agreed? So then we have to go, and if it stays with the solicitors, then it takes the pressure off of the clients when it gets to the negotiation side of things. Let us do that, because you've got your business to run. You've got other things to do. This is our job. You just let us know and we take that burden. And I think sometimes it gets overwhelming, because some clients will think like they're talking to me, they're talking to their accountant, they're talking to the buyer or the seller separately, because they're phoning each other and they know each other now. And it's just like, if it's all done through the legal and accountants and that side, it takes away that ambiguity and everybody's on the same page. Because I've seen deals in the past where they're chatting down the pub or they've gone for lunch. Right now, this is what we've agreed, but the paperwork's gone over. This isn't what's been agreed now, right? Let's start again, do this again. And yeah, so that's another big tip, is just keeping it all through the solicitors and the account, keep it with the professionals.
And you want to take accountability for that as well, don't you? Like, and as a recruiter, I want that communication. I want to be the one that is accountable for that, and just to release that kind of pressure, because you don't want one side agreeing to something because they've had a conversation directly and they feel like they had to say yes and then backtrack and then regret it, type of thing. So, definitely use the professional as a sounding board and the route to communication.
Agreed.
And with the latest budget, how's that affected timelines and people selling? Is there more? Is there less? How's that affected you?
There was a massive surge of inquiries and business selling when it was, because it was announced sort of online. We saw that it could be up to 39% for capital gains tax. So I think everybody got a little bit scaremongered and thought, right, let's do it. So we had a wave of new deals coming through. Thankfully, we got everything completed by the deadline, which we needed to do. And then it was sort of announced it was only going up a few percent, but we wasn't sure. But I suppose on the bigger deals, even that few percent could be, thousands of pounds still. So people had saved, but with sort of the business asset disposal relief rising in October, in April, that means there's going to be some sort of implications there for sellers if they're receiving money. But yeah, we've still got a big surge coming on again now, because after the budget we had another few deals come in and saying, we need to get this done and this sort of thing. So it's not sort of slowed down. It's been busy. And I think people are just taking a bit more aware of the aspects of thinking, if we get it in now, we may be able to save some tax along the line. So I'm not a tax or solicitor like that. So anything that I do say is just sort of from my own sort of knowledge and not to be taken. It's just, speak to your accountants for all money needs. Yeah, cool. Otherwise, I heard Craig Kelly say about this, and no. So yeah, it's just yeah.
Podcast is not legally binding.
Yeah, there we go. We've got it agreed. Yeah, because from that aspect, it's always best to speak to your accountants when it comes to that, especially how you're looking to structure a deal. There may be ways which could be better, more tax efficient about how you're doing things. So that's a lot of where our referrals come from, is from the accountant, because most business owners will know their accountants very well because they speak to them more than they would a solicitor. So your accountant can always recommend good, like corporate commercial solicitors that deal with the buying and selling of businesses. yeah, and it's easier then, especially if they know each other. It's great when we work with accountants we know. The relationship's a lot easier to flow. You can just pick up the phone, or it's a WhatsApp message or something along those lines if you're working with people you know, than if you don't really know them, because it results into emails and then it can take a little bit longer. So knowing that the two are, have worked together before is always a good sign to look for.
So do you get a lot of recommendations from brokers and accountants yourself? Will they recommend you as well?
Yeah, that's it. Yeah, so exactly that. So I think because, like I just said, accountants are more in touch with clients than when we probably are, because we're sort of the business side of it. We won't really see them as often. So it will come over from the accountant. They'll say, we're looking at someone to sell their business. We're at X stage, heads of terms, or we're just about to start. Can you represent our client moving forward with it? So yeah, a lot of it comes from business, from accountants, and also from the mergers and acquisition agents that we work with. So yeah, it's a good sort of community sort of thing that we all work together with it. So yeah.
We've got a few questions from LinkedIn, and mainly Marcus. One of them is, which area causes the most difficulty in reaching legal agreement between business owners?
Suppose it really starts at the beginning sometimes, is the purchase price. That can be the biggest sticking point, and sometimes we don't even get to that stage. The initial sort of talks have gone on between solicitors and the agents, getting the deal together. We meet the client, and then the purchase price is put forward, and the buyer will be like, "Oh, actually, we don't think it's worth this much." And then that's where negotiation goes, and then sometimes it can fall apart right at the beginning. Most of the time, if we can get past that, we tend to get to the finishing line. But also about with warranties and during the DD process, if something crops up about the business that the buyer never knew about, then that's also a stickler. For example, if there's an ongoing litigation against the company, which has not been discussed before, but now it's sort of doing the DD, it's come up to fruition, and the buyer thinks, well, actually, we never knew about that. Do we want to take on a company? Do we want to buy a company with this ongoing litigation, or there's an employment issue with somebody already there? And then that can happen. So it can happen at various stages, but I'd say they are the two biggest stages: the purchase price at the beginning, and then doing the DD process when all sort of the skeletons are coming out of the closet and people just don't like what they're seeing. So they're the two. If you get past those, then usually everything's been filtered out by then, and then we sort of just move on to completion. But they're the two biggest hurdles, and I say they are humongous. Yeah.
Okay, thank you. Second question was, what are the typical fees for a 1 million turnover business being sold, and then a 2 million to 3 million company being sold, roughly?
I suppose it's all based on. You put me on the spot here. I suppose it's all really based on what additionals they're going to be. So, say for example, if for the £1 million business, it's full cash on completion, there's minimal DD going on if we're acting for the buyer, and it all sort of go through the process. So, £1 million, you're probably looking in the region of maybe £5,000 to £8,000, just off the top of my head. That's sort of where you're looking. But if you've got a £1 million deal where there's deferred consideration, heavy due diligence, the paperwork negotiations going back and forth, you've got 10 versions that have gone back and forth, then it can lead into 10 upwards because of the negotiation. It all really depends on, because as solicitors we are based on the time we spend on the matters. I know that's a big aspect when it comes to for people is fees, because it's a lot of money and we understand that. So it's just about keeping the client updated. I have some clients that like me to email them on a weekly basis and just let me know where the fees are. Okay, quick email on a Friday afternoon, and then that's done. Some clients never want to speak to me. They don't mind about the fees. Just get the work done, and it works like that. So we work with all different people. But
if the kind of cost does go over what you kind of estimated, and then they're not happy, is there options, or is it a back out of the sale? I mean, it sounds extreme, right? But
yeah, but I think because we would have told you previous, and you will see the work. So we have to record everything we do. So when I send an email, I have to go onto our system and I log email to client, and it records exactly when I sent it. So you can see all the work I've done. So if I spend 2 hours on an agreement, 2 hours on the agreement, record against my time to your matter. And we can print those off and say to the client, look, this is what we've done. But 9 times out of 10, the client will know and will see that the matter has gone ridiculously longer than it should have done. We can show them the paper if they need it, say, look, this is the work we've done. And 9 times out of 10, they'll understand. But yeah, sometimes we have it, it's difficult. And like with most things, it is a difficult conversation. That's one of the things I like to do, is keep the client updated.
I was going to say that, if you've got two, let's call them easy deals, one that's going through for £30,000 at the end and one going for £1 million, your work is virtually the same on both of those.
It is.
So if you're
Exactly
looking at 5 to 8 grand on the 30 that the customer's going to receive at the end, or the seller's going to, the seller's going to receive at the end, that's quite a big percentage of that money, and they're not going to be left with too much. But the work you've had to do for the £1 million is exactly the same, and it's a lot less that's coming out of their kind of end figure.
We do take that into consideration. If it was a £30,000 deal, then obviously we wouldn't. It's not, like you said, it's not justifiable. But the deal would be easier, effectively. Yes, we're still doing the same paperwork, but the warranties and the negotiation might not be as strong because the buyer is only doing £30,000. Whereas if you're doing the multi-million deal, yes, the paperwork is the same, but it's sort of the risk is not as much, if that makes sense. So we do sort of justify and look for that, but each client is different, and that's why we have the initial first call and the initial head to terms chat with them to say, look, this is how much it's going to be, because all deals are different. No two deals are ever the same. Like I said, what I've just mentioned about the fees is just a complete off the top of my head estimate without seeing anything paperwork wise. So it can vary. It can definitely vary.
Okay. Last one from Marcus is, what has changed over the last few years in the difficulties faced by an acquirer in buying a business, and also for the seller in selling their business?
Well, again, come back to purchase price. It's sort of the sellers wanting to have a higher amount and the buyers looking to buy for a little. I've noticed the biggest change is the deferred consideration. That wasn't a big thing it was around, but I've seen it a lot more over the last couple of years, where deferred consideration is now being put forward. So a smaller sum is paid on completion, and then the deferred consideration is paid over. I've even seen it stretched over to 2 years, which is quite uncommon. Usually it's like in a year, 2 years. And so I've seen that that's sort of progressing a little bit now as well, that the time periods for deferred consideration is increasing, just to allow the business to earn the money to pay the seller, if that makes sense. So it's just it's sort of lowering the risk for the buyer, because they're knowing that the money's going to come from the business and be able to pay for it, and the seller sort of has the assurances that they've got that lump sum, but also other money is going to be coming into to them anyway. So that's what I've noticed, a big thing, deferred consideration.
It's like financing a business, really, isn't it?
Yeah, effectively, yeah.
No,
So it's
leasing the business.
We have one final question, which is from our wonderful guest last time, Isabel Shanahan. She said, if you could give one piece of advice, knowing what you know now, what would it be?
About life or about business? Is it just
entirely up to you? However you interpret that one, I guess.
This is tough, isn't it? One bit of advice would be, this is a tough one, isn't it? I suppose if I could relate it to myself, is if you're sort of, at school I did really awful. I was really bad at school, and it only took me till I got to my A levels that I actually thought, I actually can do something here with my life. And then I sort of got myself to uni and doing this sort of thing. So it would be to it sounds very cheaty, to the younger sort of side, it would be to take advantage of when you're in school, do as well as possible, to have to avoid doing extra 2 years in college like I had to do, and had to do GMVQ leisure and tourism. So I had to do that so I could do A levels. So that would be my advice, yeah. But leisure and tourism was a great course, but it was
How about you, Jack?
No, it's not dissimilar, actually. I would go back and just tell myself to not go to uni where I lived, to get off and do it properly. I mean, especially for me. I'm old enough that my uni I wouldn't have had to pay for it. So I could have gone anywhere in the country, and ended up partly because of reasons, because I wasn't great at A-levels. And I got a sort of an offer to stay in Brighton, and I stayed, and I really should have done because I didn't finish it. I went off to work and blah, blah, blah. So I'm quite, even at in my later years, I think I might sit down and have another go at doing a degree because it's one of those things. But that's what I would do. Slap down the head, go shoot,
Yeah.
be free.
How about you, Matt?
I think to enjoy the present and to enjoy the kind of time and the journey that you're going through, good, bad, indifferent, and just kind of experience it and be present with, I'm having a really terrible time at the minute. It's going to pass. But then also, like during the good times, just appreciate them for what it is and where you are, and just stick to your, like, just do it in your own time and stuff like that. So very philosophical. I can't even say the word.
Like
but yeah, just be present and just accept for, just because you're, I don't know, 25 doesn't mean you have to have a car and marriage and a house and stuff. Just be comfortable with yourself and your own journey.
Yeah, good.
This too shall pass.
Very zen.
Absolutely.
How about you?
I've got two ones actually. Two of them. I've got work-wise. Pretty much this for me. Try new things. I don't think I would have done this much earlier, and I don't really know why. Maybe it's just a bit of a confidence thing with me. But I should have done, going on podcasts, talking in public, and speaking, and doing bigger demonstrations to people. Just go for it. What's the worst that can happen? I think, there hasn't been any bad thoughts with this podcast. No one said, Andy, you're rubbish. Not to my face anyway. Just give things a go. Give things a go, and what's the worst that can happen? And on a personal level, a really boring one, start saving for mortgage deposits and those kind of things a little bit earlier, maybe. Not going to nightclubs quite so much as I did as an 18-year-old, and maybe just putting the odd 50 quid away just to help myself out a little bit earlier, perhaps. Pretty boring, that one.
You stopped going to nightclubs, have you then, Andy?
No comment. Craig, that's been brilliant. Thank you ever so much. And I hope all the listeners and viewers have got some real value from what you've said today. How would people reach you if they wanted to get in touch?
I've got my LinkedIn profile, my email address. I can send that, guys, to you. I can put it somewhere. That's not a problem. Yeah, or on the Aquabridge website. I'll be different because I haven't got my moustache or my glasses, or so I might look a bit different in my picture. But this will be gone tomorrow anyway. So yeah.
Quite especially in November. I love
It's
that.
a sterling effort, Craig. Well done.
Very good effort.
Yeah, thank you. It's good. It's good with the white background. That's why I sat here. That's why I did it. Really. Yeah, it sort of shines out a bit more. But no.
That's great. Thank you very much, guys, and we'll see you on the next one.
See you soon.
Cheers, guys.
Thanks very much.
Bye-bye.
Cheers.
Cheers.
See you
Bye.
later.